Welcome to Real Estate Radio Power Investing, an informative and engaging hour discussing everything you need to know about the world of real estate investing. Your host, Tom K. Wilson, provides you with insight and guidance from his years of experience as a successful real estate entrepreneur on how to buy, sell, finance, and invest in real estate, and much more. Now, here's your host for Real Estate Radio Power Investing, Tom K. Wilson.
Thanks for tuning in to our Real Estate Radio Power Investing program, where we empower you with the education to maximize your investing success. We're broadcasting from the Silicon Valley corporate headquarters of Wilson Investment Properties, the sponsor of Real Estate Radio Power Investing. Wilson Investment Properties is a syndicator of commercial properties, where for typically $50,000 a share, you can participate in commercial properties ownership that typically only large institutional investors can benefit from. Go to wilsoninvest.com for a lot of education information on this topic, frequently asked questions, and you can also look at all of the 6 years worth of broadcasts and podcasts we've done on real estate investing with folks like our guest today, Mauricio Rauld, Dr. Doug Duncan, Chief Economist of Fannie Mae, Robert Kiyosaki, Bruce Norris, Robert Helms, and many other folks who are very, very experienced in the whole world of real estate investing. I'm Tom K. Wilson, your host for this weekly radio show on multifamily and commercial investing and syndications. If you can't make the live show, you can catch your podcast on wilsoninvest.com. You can also go to baycom.club, BACOMM, Bay Area Commercial and Multifam, for information on our monthly education meetup venue on commercial and multifam investing with world-class speakers such as ones I just mentioned who've also been on our radio show. And Mauricio Rauld, our guest today, will be, if you're listening to this podcast or broadcast before August 22, 2019, he will be in Silicon Valley to speak at Baycom on August 22. So go to baycom.club or to wilsoninvest.com to get more information and to sign up for that program. So today we have Mauricio Rauld with us to talk about syndications and the law regarding it, and we'll recap the prior program we did with Mauricio and talk about opportunity zones and how you can advertise and not advertise to keep you and your investors safe. We will start off with a recap. I want to introduce Mauricio again. Mauricio is an attorney who specializes in syndications, private placement memorandums. He's one of the few lawyers that actually speak English. He's takes complex matters and makes them easy to understand. He's a graduate of UC Berkeley and Loyola Law School, founder and CEO of Premier Law Group, and indeed a national educator and speaker and expert in asset protection and private placements. Mauricio, welcome back.
Well, thanks for having me back, Tom. Really appreciate it.
We've known each other for quite a few years. Met on Real Estate Guys Summit at Sea about, I think, 9 years ago. Mm-hmm. And we've been connected ever since. And I, at the time we met, I had no idea that we would wind up with being in the arena of investments in the commercial area with private placement memorandums. And indeed, Wilson Investment Properties has now had 21 of them across the country and about $300 million worth of assets under management. And you certainly provided a lot of education, information, and encouragement for us to go down that route, and it's certainly been a good path. But it is certainly not for the weak of heart, and it's certainly a path that needs to be treaded very carefully. The SEC, certainly if I've gained anything from this experience outside of the thrill of providing investments for our clients, it's that the SEC is a lot more ominous than IRS or any real estate board or so forth, and you need to be very, very tuned into what's the right way to go about it. Would you concur with that?
No, absolutely. And, a lot of people ask me, why is the SEC even involved, right, Tom? I mean, here we are you're buying commercial real estate. A lot of my clients are buying apartment complexes, other real estate things. And the question always comes is, why is the SEC even in my business, right? But you're right. It's absolutely an onerous regulatory body, and the consequences for you violating some of these securities laws can be, as bad as going to jail and becoming Bernie Madoff's cellmate, which is the last thing we want to do. And my job is to make sure we comply with all these laws so you avoid having any of the SEC and also the state too, right? Don't forget about the state. They still have some power, and they still have some oversight on what you do. And so you've got to be careful for both the SEC and also the state regulators.
I think many people maybe don't understand that when they're investing in a private placement memorandum, they are buying stock, just like they would for Apple or Google or anything else. But it's private stock. If it's 506B, which is what most under Reg D, which is what most syndicators do, it is only available to those that have a relationship with that syndicator. But there's still strict requirements. But they are buying stock. Now, the good part about it is that the manager, the sponsor of the syndication, is the one that's really taking on the responsibility and liability for that. And the nice part about the investors buying stock is that they don't have liability. So they're very passive. They have to be passive, or they couldn't have that liability protection. So for the investor, it's a really, really good route to go, and it's up to syndicators like us to be very careful and keep all of us out of trouble.
Yeah, and Tom, and just to echo one of the things, I want to make it clear, because this is one of the misunderstandings too, is yes, you're absolutely true. You are buying a stock, or if you're doing an LLC, obviously a membership unit, but it's not limited to stock. So the actual structure itself, even though I know you use an LLC, most of my clients use an LLC, but getting around that doesn't help you, right? So the structure itself, whether it's an LLC, an LP, a corporation, a profit sharing agreement, a handshake, a high five, whatever it is, the structure itself doesn't matter. The real issue is anytime you take money from an investor where the profits are generated by your efforts, in other words, your investors are passive and you're doing all the work, you're the active one, then you're dealing with a security. And again, whether it's an LLC or a TIC agreement, I see a lot of people trying to get around the securities laws by structuring it in some unique way, and the structure is completely irrelevant. It's whether your investors are passive and you're doing all the work.
Well, maybe I'm not taking the typical perspective of some folks, but to me, the objective is to be very very conservative, to vet your products extremely well, to disclose everything that you possibly can that you've learned to your investors. And my position's kind of been, we certainly have got great legal counsel that helps us follow the letter of the law, but in the end, I feel like doing the right thing of really disclosing, vetting, really taking care of your investors and getting really good quality products is probably what minimizes the risk for everybody the most.
Yeah, for sure. And having that relationship, it's such an important relationship to have with your securities attorney, because the only way your securities attorney really can understand your particular deal and understand all the risks involved in that individual project is to have that relationship with you and ask you all the questions and really take a deep dive into what you're doing, so that they can actually understand what the risks are, but also pull some of that information out of you that you may not even realize, maybe some type of risk or some kind of disclosure. And so it's critical to have somebody that you have that communication level with, that you can then turn around and then put all that information into that disclosure document, which is the private placement memorandum.
I'm kind of surprised with some syndicators I've talked to that, and some just investors in real estate in general, that they often consider their legal group to be an adversary and their lender to be an adversary, and I tell them no.
What I used to do was litigation, right? And so I used to be on the other side of the opposing party, and it was a very adversarial adversarial situation, and my clients, would hire me once there was a lawsuit and there was all this negative stuff. And now it's so much more interesting because at least my clients and we're all aligned. We all want to get this thing done. The client needs me and wants me to do a good job so they can go and close their deal and raise the money. And of course, I'm trying to help the client get there and get to the next one. So you definitely have an alignment. I would hope nobody's thinking of this as sort of an adversarial. You want your attorney, you want a good one. And the more times you work with the attorneys, the better you get to know each other and the easier the process becomes.
Sure. Totally agree. We're going to take a short break. We have Mauricio Rauld with us, a expert attorney in private placement and asset protection, and we'll be back in just a moment.
Welcome back to Real Estate Radio Power Investing. Streaming live on iHeart, TuneIn, and KDOW.biz. For more information on today's topic or guest, visit wilsoninvest.com. That's wilsoninvest.com. Again, your host for today's edition of Real Estate Radio Power Investing, Tom K. Wilson.
Welcome back to Real Estate Radio Power Investing with Mauricio Rauld today, an attorney with a lot of experience and expertise in the area of private placements, syndications, asset protection. So, Mauricio, if you will, let's take a little bit of time to kind of recap for those that maybe didn't catch the prior podcast or would like to have a little refresh, and just give the overview of what a syndication is and what it's regulated by and how it works.
Yeah, let's do this as simple as we can. So a syndication, many people who haven't heard of the term before think of a syndication as like a syndicated television show or syndicated radio show, and that's obviously not what we're talking about.
I've actually had some that think of it as maybe a mob in Chicago, and I've had someone ask me, is it legal?
Yeah, no, a syndication is, in our context, is quite simply the pooling of resources in order to go do something. And those resources, most people think of these resources as money or as capital, but it really can be other things like, your credit, your relationships, your time, your energy. There's all kinds of things you can do, but you pool that with other investors. And then you go, in my case, you go buy, apartment complexes. In your case, you do a lot of commercial investing. So it's just that act of pooling. And as we discussed in the prior segment, when you do that, you're issuing a security, and therefore you fall into the securities rules. And there's really three things we think about when we fall into the securities category, and that is, number one, we need to register that security with the SEC, the Securities and Exchange Commission, or we find an exemption to registration, or number three, it's illegal. It's that simple. And so we obviously don't want to do anything illegal, but, illegal isn't just, committing fraud and doing the Bernie Madoff stuff, right? I mean, obviously, if you're swindling your investors, that's going to be a problem. But it can be little things like, not little things, but it can be other things like not providing full disclosure documents, providing a PPM when necessary. It can be, over-exaggerating some numbers without giving the proper disclosures and kind of giving a more balanced approach. It can be, something like paying referral fees for somebody raising money for you. It might be the social media where you're advertising on social media when you're not supposed to, which I know we'll talk about that in a little bit. So there's lots of things that fall into that illegal category that goes beyond just swindling your investors. So we obviously don't want to do that. We also don't want to register the security because it just takes, it'll take you 12 to 18 months if you're lucky to get that through the government process and, deal with all the attorneys.
So, Mauricio, if you will explain what quote unquote the registration means, which is and what's different about what us syndicators do generally rather than registration.
So the registration is a process where you actually deliver your documentation and your offering before you send it to your investors. You actually file it with the SEC, and you basically get your deal approved by the SEC. And that's a time-consuming process because you file it, they review it, they give you comments, it gets back to you, you send them another draft, they review it, and you kind of go back and forth. And as you know, the government is not exactly the most streamlined entity out there, and so it just tends to take a long, long time. And then, of course, you still have to deal with all the states. And so if you're selling in all 50 states, now you've got to deal with all of those state securities laws. And so the registration process, that act of getting your deal approved prior to being able to share it with your investors is just a really time-consuming process and expensive. And think about it. If you're an investor, you're a syndicator who's in contract to buy a building and you've got 90 days to close, you just don't have time to go through this registration process and deal with all that nonsense. And so we really try and avoid a full-blown registration at all costs, which is why we're always looking for an exemption to registration, which is number 2, which is really where I live, and that's where I spend all of my time is primarily, the 2 exemptions that 90 to 95% of the people rely on, which you referenced a little earlier, which is the 506B as in boy and the 506C as in Charlie. And those are the 2 exceptions that fall under this general Reg D exemption, which some of you may have heard.
Before you
that most people rely on.
Before you jump into that, let's just one more thing I wanted people to understand. They're probably thinking, well, registry, it sounds awful. Who would do that? So that's your typical public offering or our initial public offering, IPO, that a corporation that is sizable that wants to raise stock publicly, that's the process they go through to allow them to do that. And it can cost, like you said, take many, many months and cost hundreds of thousands of dollars to do that.
Yes. Yeah.
But if you're an up and coming Uber or Google or whatever, that's what you do because you're trying to raise huge amounts of money.
Yeah, although these days, and when we talk about kind of summarizing what we talked about in the last episode about these exemptions, one of the nice things about both of these exemptions is that you are allowed to raise an unlimited amount of money. So even the big boys like the JP Morgans and the Goldman Sachs and the Merrill Lynches, they still raise money under 506B or 506C because they can rely on these when they're raising $1 billion. I think I just saw a JP Morgan fund that's $1.2 billion for a real estate fund. So even the big boys rely on these exemptions because of that nicety that you can raise an unlimited amount of money. So there's really no restrictions there. And I'm happy to go kind of do the quick overview.
Yeah, let's do the overview on 506B and C just so folks have a general feel.
So 506B was the original one that came through, and that's the one that everybody used to rely on because that's the only one that people could really rely on. And that does allow you to raise an unlimited amount of money, and it allows you to take a limited number of non-accredited investors. And just to kind of recap there, if you remember, an accredited investor is anyone who has a net worth of over $1 million, excluding their primary residence, or has earned $200,000 the past couple of years with a reasonable expectation of earning that this year, and that number goes up to $300,000 if you're married and filing jointly. And so in a 506B, you're actually allowed to take up to 35 non-accredited investors, so long as they're sophisticated, but that gives you a little bit more wiggle room and able to really invite your friends and family that inevitably 1 or 2 of those will be non-accredited. So that's kind of the appeal of a 506B. You can raise an unlimited amount of money. You can take up to 35 non-accredited investors. The big drawback is clearly the lack of your ability to advertise or generally solicit. So you really do have to have, generally we have to have what's called a pre-existing substantive relationship with somebody that's already in your network, somebody you already know. You cannot go out there and market your deal to Facebook or at a presentation or a radio show or a seminar or whatever creative ways, or put an ad in the Super Bowl or whatever newspaper. That's prohibited, and that was the main limitation that we had, which is really the reason why this 506C came along about 5 years ago.
Okay, go ahead and just quick overview on C, because not many folks deal with that. But
So 506C came online in September of 2013, and the main beauty of it is that it lifted that prohibition against advertising. And so now, if you rely on a 506C, you can do whatever you want in terms of marketing. You can put in, like I said, kind of joked about taking an ad out in the Super Bowl, doing Facebook marketing, social media marketing, going to conferences, passing out your business plan, hiring, doing whatever you want to advertise in the market without any restrictions whatsoever. Your only limitation, or the main difference now, is that you can only accept accredited investors only, and you must take what's called reasonable steps to verify their accreditation status. So under a 506B, which we just talked about, you could rely on their representation. We would send people a questionnaire. They would check the box. They would say, yes, I'm accredited, or no, I'm not. And that's the end of it from our standpoint. With a 506C, you can't do that. You have to take that additional step of verifying. And that typically involves, the most common way to do it is you actually get a verification letter from that investor's CPA. That's probably the most common way. And then in addition to that, you can start, requesting tax documents, obviously tax returns or W-2s or what have you, to prove that their income level is there. And if they're relying on their net worth, then you're looking at bank statements and brokerage statements and real estate appraisals and credit reports and all that stuff to show actually prove that they have that $1 million in net worth.
I've never read the history about it, but it seemed bizarre to me that their objective, as I understand it, 506C, was to allow the general public to get access to things that normally only individuals that had a relationship with syndicators could invest in. So here they open it up. You can general advertise. Somebody will be listening to our radio show and say, "Oh my gosh, that sounds great! I'm interested." And yet, it's only accredited investors. So I wonder if that was an 11th hour backroom thing. Like, sound like a good idea to let the general public in, but I'm a little nervous about it. Maybe we better make it more restrictive.
You got to remember, this came out in the 2002 Jobs Act, and this was right after that, a couple of years following the Great Recession. So, the capital markets were pretty frozen. People were trying to get economic activity going, and so they came up with this idea of really kind of loosening up the rules here to invest. But they came with the idea that if you're going to advertise and take money from people you don't know, then those people better be sophisticated and really know what they're doing. And unfortunately, they rely on this income or net worth qualification to determine whether somebody is sophisticated enough or smart enough to invest, when we both know, plenty of us know, really high net worth individuals who are the dumbest people in the world. And conversely, a lot of people who don't have the resources but are super smart and could argue and know much more financially than some of the other high net worth individuals. So it's arguably not a very good, not a very good marker to determine whether somebody's qualified or not.
Sure. So let's take a break here, and then we come back and we're going to talk about the do's and don'ts about advertising for syndications and social media and so forth. We have Mauricio Rauld with us today on Real Estate Radio Power Investing, talking about private placement memorandums, the SEC regulations and rules, and we will be back in just a moment. Stay with us.
Welcome back to Real Estate Radio Power Investing. Streaming live on iHeart, TuneIn, and KDOW.biz. For more information on today's topic or guest, visit wilsoninvest.com. That's wilsoninvest.com. Again, your host for today's edition of Real Estate Radio Power Investing, Tom K. Wilson.
Welcome back. Real Estate Radio Power Investing with Mauricio Rauld today, talking about SEC regulations and syndications in general. So, Mauricio, talk to us about the do's and don'ts about advertising for syndications and social media involvement and so forth. Continuation of the topic we were on before in the last segment.
Yeah, so this comes into play when you're relying on primarily on the 506B exemption or any exemption that prohibits advertising in your offering. And so, obviously, if you're doing a 506C or some other that allows advertising, this doesn't apply. You can do whatever you want. But if you're prohibited from advertising, then you are prohibited from making an offer of your securities in any public mean. And that does include, obviously includes what most people think of a public mean in advertising, radio shows, podcasts, seminars or what have you. But it does extend to social media, for example, which a lot of people either don't think about or just don't think that it's a big deal, and so they do it anyway. And it also extends to your website. And people forget that your website is a public source, and that gets blasted out to the world. So you're just not only prohibited from pitching your deal directly in these mediums, but you're also prohibited from putting together a webinar or a seminar or an event that then you go ahead and pitch the deal. So you just got to be really, really careful. And what I think most people miss, especially in the social media world, and I'll talk a little bit about specifically about social media, because I think I'm very actively involved on Facebook, and I just see this every single day, people violating these rules. But what people have to remember is that an offer, which is what the SEC regulates, an offer of your deal is a pretty broad definition. It's not just the direct offer of your security. So obviously, if you say, hey, I'm raising $1 million to go buy this commercial building, that's obviously going to be an offer or advertising. But it also contains what's called conditioning the market, which means anytime you stir up interest in your deal. So if you're out there talking about, hey, my investors are getting a 10% return, or come invest with me because I got great ROIs, and you're just drumming up interest in your deal, then the SEC is going to consider that as an offer and basically advertising your particular deal. So I think that's where most people get caught up and not realizing that a lot of the stuff that they're posting about, hey, I just got into contract with this deal and my investors and I are super excited, or whatever, that all kind of crosses the line and becomes an advertisement. And what happens in those cases is once you advertise in your deal, you've essentially blown that exemption, that 506B exemption, because, again, you're prohibited from advertising. So you're no longer eligible to use 506B, and now you're forced to go find a different exemptions that you hopefully can fall under. And the easiest one, of course, would be 506C, but now you won't be able to accept any non-accredited investors, and to the extent you already have some, you may have to kick them out. And
so you would agree, wouldn't you, that it's pretty it's okay and pretty fair to at least to state what you've done in the past?
Yeah. So the
factual history.
Factual history about your company. So
and how about products that you've bought and how they perform?
I'd be careful on the product. I mean, you can certainly, as part of what your business does, right? You're talking about your business, what your philosophy is. Hey, I'm a real estate investor. I'm a fund. My corporation invests in these types of asset classes, and here are some of the assets that we've purchased in the past. That's fine. You're starting to get a little bit into gray area, but as long as you're just listing, hey, this property we bought in 2018, this property we bought in whatever. Here's our portfolio essentially. But where people cross the line is that they start talking about the returns of those prior deals, and talking about returns of the prior deals and the ROIs or the investor, how happy the investors were on this deal because they all made a 15% return. That's where you start crossing the line, because now you're, again, the only reason you're doing that. I mean, let me just ask you, what's the purpose of doing that on a social media or on a website? The sole reason to do that is to drum up interest for your next offering, and so that's going to be considered conditioning the market. So you really want to limit your presentation or your facts to really factual things about your business, what types of things you do. And it's totally fine to somehow get a capture of that individual. So either, hey, call me for a free consultation, or here's, if you want this report on the market of, here's at the San Jose real estate market, the state of the market. I've done a report on this. If you want the report, email me. You can capture that information, but now you've got to go through a process where you take this complete stranger that you've never met before. You've got to go through a process to take them from a complete stranger all the way to establishing a substantive relationship with them, so that then you can offer them a future deal. You still can't offer them the current deal that you have, because, again, you have to have a pre-existing substantive relationship, which is pre-existing to the offer.
So stay with us with Mauricio Rauld on Real Estate Radio Power Investing. We will be right back.
Welcome back to Real Estate Radio Power Investing. Streaming live on iHeart, TuneIn, and KDOW.biz. For more information on today's topic or guest, visit WilsonInvest.com. That's WilsonInvest.com. Again, your host for today's edition of Real Estate Radio Power Investing, Tom K. Wilson.
Welcome back, Real Estate Radio Power Investing with Mauricio Rauld today. So just briefly talk to us about what's sufficient in a relationship for someone to be offered a 506B.
Yeah, so the SEC, and I actually did a video on this, I think it's still up on my YouTube channel, but I did a video on this where I walked you through the 6 steps that the SEC has basically provided. It's basically the best guidance we've received, and it's through what's called a no-action letter, and it's called the Citizen VC no-action letter. And a no-action letter is simply, you have the ability as a syndicator, if you have kind of a unique set of facts and you're not quite sure, how if this is legal or not, and maybe it's a gray area, you actually have the opportunity to write to the SEC. Obviously, your attorney typically writes to the SEC, provides them with the fact pattern and says, hey, if we do this, will you take any action against us? Kind of you're trying to find out ahead of time. And not always, but sometimes the SEC will respond and say, nope, if you do exactly what you're telling me in this letter, we will take no action against you. And that's what happened in this particular case. It's the Citizen VC. They had a website specifically, and they basically, it was a compliant website, except they acknowledged that they captured some people, that they did not know or did not have a relationship with. And they went through this process and procedures that they had in place. And I think there were 6 of them. And those included, for example, providing them with a very detailed, specific questionnaire. That was kind of step number 1. And when I say questionnaire, I really think about those questionnaires that you get when you're, opening up an options account or something on your brokerage account, all those questions about your experience, your level of sophistication, your net worth. So there's a questionnaire that you send out. You then get on the phone with them or have a meeting with them and spend, 15, 20 minutes with them and get to know them a little bit better. Invite them to ask questions about you and your company and the types of deals you do. Basically in general, foster that relationship with. And the SEC was very clear that there's no magic timeline, right? A lot of people think of this 30-day cooling off period or this type of time frame. The SEC was very clear that it's not the time that's involved, but it's the quality of the interaction. So it's going to be kind of the facts and circumstances. But it's really up to you to decide at what point you feel like you've done enough, you've had enough calls with them, you've had enough email exchanges, you've had enough interaction with them, that you at some point say, okay, as of today, I've considered that this person I do have a substantive relationship with. You somehow capture that in your CRM or however you keep track of your investors. You want to definitely keep track of who you know and who you don't. And then you can say, hey, on July 1st, I'm just making up a date here, I have a substantive relationship with. And so moving forward, the next deal you have, not the current one, but the next one, you could then email them and make them an offer of your future offering.
Okay. Good stuff to know. Let's come back after the break, and let's start talking about a lot of people's favorite subject, which they don't know much about, and a lot of misconceptions and confusion about, and that's opportunity zones. So stay with us with Mauricio Rauld on Real Estate Radio Power Investing. We will be right back.
Welcome back to Real Estate Radio Power Investing. Streaming live on iHeart, TuneIn, and KDOW.biz. For more information on today's topic or guest, visit wilsoninvest.com. That's wilsoninvest.com. Again, your host for today's edition of Real Estate Radio Power Investing, Tom K. Wilson.
Welcome back, Real Estate Radio Power Investing with Mauricio Rauld today. And we are broadcasting from the headquarters of Wilson Investment Properties, a national syndicator of multifamily commercial properties. Mauricio, we get a lot of questions about opportunity zones, and we've certainly looked into it. We aren't, we learn every day, but it's not a new topic to us. We felt like for our clients it wasn't a great fit, but everybody's curious about it. There's certainly a lot of folks that are, looks like they're being able to take advantage of it, make some money from it. Talk to us about opportunity zones, maybe define what it is, and then talk about the legal aspects of it.
Yeah, so an opportunity zone is quite simply a geographical area that the government, along with the governors of every state, has decided that they are in need of some capital injection. They're dilapidated areas. I always think of Detroit, Michigan, and I apologize for anyone from Detroit, but that's kind of what I think of when I think of an opportunity zone. So they're just desperately needing capital. People are not investing in those areas, and so the government is trying to steer some capital into these areas, create jobs, create real estate movements, businesses.
What about the legal aspects?
Well, let's talk about some of the bad stuff, right? So that's the good stuff. The bad stuff, or the limitation, I think, at least in my world, being in the real estate world, this applies to real estate and businesses as well. But again, my world is real estate. 100% of my practice involves real estate investors, so I haven't really been paying too much attention to the business side of it. But on the real estate side, you have a requirement to what's called substantially improve the property that you're buying. And again, it makes sense from what the idea here is. Again, it's to spur economic activity. So the idea is you buy a piece of property, then you must invest the same amount of money that the property itself is worth. You've got to put that amount of money into the project within a 30-month period. So, for example, if you buy, a single-family home, and probably not single-family, but if you buy a property for $100,000, and let's say you say 20% of that is the land and 80% of that is the property itself, then you must invest an additional $80,000 into improving that property within that 30 days in order to remain as a qualified opportunity zone fund and continue the benefits of both the deferral and the 10-year gap. And so, again, in my world, and you and I were talking about this a little bit offline, my clients typically are buying, real estate. They're certainly making some value adds to it, but they're not making that much value add. And so I feel like this is really geared more towards developers, because actually when you buy raw land, you don't have that requirement. You don't have a substantial improvement requirement when you buy raw land. But even if you did, obviously, ground up construction is expensive. You're going to be putting a lot of money into it anyway, so you probably would have gotten there anyway. But you don't have that requirement. And so for developers, it makes a ton of sense. For, real estate investors in terms of apartment complexes, or in your world, the commercial real estate, I'm not so sure. I guess time will tell.
So, again, everyone go to wilsoninvest.com to pull up any of our past podcasts, to also look at education information about real estate investing through syndications for multifamily and commercial, and a lot of education information there. And if you sign up to our newsletter, then you start the process for which you get a relationship with us so that you can get access to our syndication deals, which are typically $50,000 a share, so you can invest in products that normally only larger investors can invest in. And we're always available to answer your questions. So thank you again, Mauricio, for being on with us today. We look forward to having you out here in August. Always a pleasure to talk to you. Thanks for being on Real Estate Radio Power Investing.
Thank you, Tom.
Thank you. And so remember, the only thing that matters is what you do next. Be with us for our next program.